3 years ago, the Supreme Court told local governments they could not keep more of your home's value than the taxes you actually owed. This year, unanimously, the same 9 justices told those same governments exactly how little that promise might actually be worth in practice. This is the story of 2 cases, 3 years apart, both decided 9-0, and how the second one quietly narrowed the first without ever technically overturning it. If you want to understand exactly how the takings clause works in tax foreclosure cases and where the real fight is headed next, this is the legal mechanics behind it. Quick housekeeping. I trace how one Supreme Court ruling actually builds on, narrows, or clarifies an earlier one, because that relationship usually tells you more than either ruling read alone. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into the actual constitutional reasoning here. Start with Tyler versus Hennepin County, decided in 2023, because Pung cannot be understood without it. Geraldine Tyler, a 94-year-old Minnesota woman, owed roughly $2,300 in property taxes on a condo, a debt that grew to about $15,000 once penalties and interest accumulated over time. Hennepin County foreclosed, sold the condo for $40,000, kept the full amount, paid itself the $15,000 debt, and retained the remaining $25,000 as pure profit, standard practice under Minnesota law at the time. The Supreme Court ruled unanimously that this violated the Fifth Amendment's takings clause, which prohibits the government from taking private property for public use without just compensation. The court's reasoning drew on a long-standing principle in American property law, going back through English common law, that a creditor can only take what it is owed, not more, even when the creditor is the government itself collecting a tax debt. Keeping the $25,000 surplus was, in the court's reasoning, simply a taking without compensation, dressed up as tax collection. Tyler was a genuinely significant ruling, but it left a specific technical question completely unaddressed, and that gap is exactly what created the opening for the case decided this year. Tyler established that homeowners are owed their surplus equity after a tax sale. It said nothing about how that surplus should actually be calculated. 2 candidate methods exist, and they can produce wildly different numbers. The first is fair market value, an estimate of what the property would sell for through an ordinary arm's-length transaction, the kind of number a real estate appraisal or a county tax assessment typically reflects. The second is the actual sale price realized at whatever specific foreclosure sale process the property went through, frequently a public auction, which by its nature often produces prices below fair market value. Since auction buyers are typically investors looking for a discount, sales happen on compressed timelines, and the pool of bidders at a tax auction is usually smaller than the pool of buyers in an ordinary real estate market. This is precisely the question Pung versus Isabella County put before the court. The Pung family's Michigan home, independently assessed by the county's own assessor at $194,400, was foreclosed over a tax debt that had grown to $2,242 and sold at a tax auction for just over $76,000. Under a fair market value reading of Tyler, the family would be owed a surplus calculated against that nearly $200,000 figure. Under an auction price reading, the surplus is calculated against the roughly $76,000 the property actually sold for, a difference of well over $100,000 in what the family could recover, depending entirely on which baseline the court chose. Here is the court's holding, unanimously in an opinion authored by Chief Justice Roberts. The proper baseline under the takings clause is the price obtained in a tax sale, not an estimate of fair market value, at least when the sale is fairly conducted, consistent with the country's historical practice around tax sales specifically. The reasoning leans heavily on historical practice, a recurring theme in how this court currently approaches constitutional questions generally, arguing that tax sale auctions have long been treated in American legal history as legitimate mechanisms for establishing a property's relevant value for this specific purpose, distinct from, and not required to match, an open market appraisal. The court effectively held that the Constitution does not require the government to guarantee homeowners the benefit of a hypothetical, more favorable sale process, only that whatever sale process is actually used be conducted fairly, and that any genuine surplus it produces be returned. That final phrase, conducted fairly, is doing enormous legal work in this opinion, and it is exactly where the case's real remaining uncertainty lives. The court did not resolve the Pung family's case outright. It reversed the lower court's more favorable ruling and remanded the case back down to the Sixth Circuit Court of Appeals for further proceedings consistent with this new standard. That remand is not a technicality, it is where the next phase of this exact legal fight is going to happen. The Sixth Circuit and lower courts handling similar cases in other circuits going forward now have to work out what actually counts as a fairly conducted tax sale under this new standard. Questions like whether notice to the homeowner was constitutionally adequate, whether the auction had genuine competitive bidding rather than a single insider buyer, whether the specific procedures used departed from historical tax sale practice in some way significant enough to make the resulting price constitutionally unreliable as a stand-in for the property's real value. This is worth situating within a broader pattern in how this court has been deciding property rights and takings cases generally over the past several years, because Pung is not really an isolated development. The court has shown a consistent willingness to root modern takings analysis in specific historical practice rather than in broader, more flexible fairness principles, the same methodological instinct that shows up prominently in the court's Second Amendment cases applying the Bruin historical tradition test and in various other property rights contexts. Tax sale auctions have a genuinely long history in American law, arguably a much more settled and specific one than the question of what modern fair market value even means in the abstract, which gave the court a relatively clean historical anchor to root this ruling in, consistent with its broader current approach across multiple, seemingly unrelated areas of constitutional law. There is also a legislative and political dimension worth understanding, because Pung landed in an environment where Tyler had already triggered real reform activity, not just litigation. In the 3 years since Tyler, a number of states moved to strengthen their own tax foreclosure surplus protections beyond the federal constitutional minimum the Supreme Court requires, some adopting fair market value-based calculations voluntarily as a matter of state law, even though Pung now confirms the federal Constitution does not require that specific approach. The House Committee on Oversight and Government Reform has separately invoked Tyler directly while pushing for broader reform and requesting briefings from local governments accused of maintaining practices closer to what the court struck down in 2023. Pung does not touch any of that state-level reform activity at all. States remain completely free to provide homeowners with stronger protection than the federal constitutional floor, including a full fair market value guarantee if a state legislature chooses to enact one, meaning your actual practical protection increasingly depends heavily on which state you live in, not just on the federal constitutional minimum this specific ruling establishes. Step back and look at what this two-case sequence demonstrates about how a broad constitutional principle actually gets implemented in practice. Tyler announced a rule with obvious sympathetic appeal. The government cannot pocket your home equity. Pung, decided by the same unanimous court just 3 years later, answered the far less dramatic, far more consequential technical question of how much that rule is actually worth, and answered it in a way that meaningfully favors the position local governments across the country had been advocating for since Tyler came down. This is a genuinely common pattern in how landmark rulings actually function over time. A broad, popular principle gets established first, generating significant public attention, and then a series of narrower, more technical follow-up cases determine how much that principle is actually worth to the people it was meant to protect. Follow-up cases that typically draw far less public attention, despite frequently mattering just as much or more to the actual dollar-figure outcome for real people in real situations. If breaking down the actual constitutional reasoning behind this ruling, not just its practical effect, was useful, hit like so it reaches people trying to understand how the Takings Clause actually works in this specific context. And subscribe if you have not, because the Sixth Circuit's handling of the fairness question on remand is going to be the next meaningful development in this exact area of law, and I will cover it once it happens. Tell me in the comments whether you want the next video to track how individual states are responding to this ruling with their own legislative reforms, or to go deeper into what a fairly conducted tax sale is likely to mean once the Sixth Circuit actually rules on it.